The people of the state of Michigan versus Ashley Page Barnhill. And this is the People's Emergency Motion regarding bond.
Thank you, Your Honor. We got a very disturbing voicemail from the father of this child, who is also the victim in this pending case, really begging for somebody to do something because CPS wasn't doing anything. And
that is not a surprise.
Correct.
Were they called?
Yes,
Okay.
Yes. And what I'm asking for fundamentally here, Judge, is that you revoke her bond. And I will go through all of the reasons I think that is absolutely necessary in this case, not only to keep the community safe, but to keep these children safe. Because this defendant is a danger to not only her children, but to any child. Your Honor, I actually remember that case when I was your docket prosecutor a few years ago. And why do I remember that case, Your Honor? It was a CCW, but there was another component to it. Because the child's father, right, who's the victim in this case,
was the victim there.
Yes, because he called police and said, this defendant tried to hit me with her car. We couldn't proceed on that count because he didn't want to get her in trouble. You know, he wanted to work things out with her. She was 12 weeks pregnant at the time. So she's driving a car allegedly, trying to hit the father of her soon-to-be child, which is the victim now in this case. And how does that argument start, Your Honor? Over marijuana, over weed. And I'd like to point out that I read her the PSI for that case, and she told this court and the PSI writer, oh, I stopped marijuana. I stopped all of that when I found out I was pregnant. Incorrect. By her own admissions, at 12 weeks pregnant, she's trying to get marijuana and ingest marijuana. So now let's talk about the case that she's currently on bond for. Okay, this is a child abuse third case. And how does this start about? The child, and not just a child, we're talking about a 12-month-old baby, right? So she gets into it with the father of this child. He's making some sort of cake for someone's death. And she's mad that he's spent money on that cake, probably because it's taking money away from, I don't know, maybe some illicit substances. So what does she do, Your Honor? She throws the cake to the ground, and then he grabs her phone, and in an effort to get her phone back, she uses the 12-month-old baby as a bargaining chip, grabs that baby so tightly around the arms that it leaves red marks on the arms of this 12-month-old.
Can I interrupt you? Was she with the victim? Because there's a no contact order. Is that how she knows about the cake and throws the cake?
If there was a no contact order as part, so the cake incident is those facts are why she's on bond right now, to Your Honor. And I don't believe there was a no contact from the CCW.
Okay.
Does that make sense?
Yes.
And he takes the kid, and what does she do in response, Judge? She takes 2 knives, follows him, tries to get in his face, and then begins stabbing the walls. While the child is still there, over what? Money? I mean, that's so what I'm saying, Your Honor, is that is incredibly dangerous behavior, right? We're seeing an escalation. We're seeing this pattern of violence. We're seeing this pattern of her putting herself, her needs, her wants above children, above her own child, and above a baby. Between June 6th and June 7th, the child is now 14 months old, was admitted to the hospital for a marijuana overdose, okay? And this 14-month-old was asleep for 15 hours, which Your Honor knows well with children, that is incredibly dangerous. They need to eat every 3 to 4 hours. And the fact that that baby is completely asleep for that amount of time is very dangerous. And so how do we find out about this? Well, it's not the defendant telling CPS. Nope. It's not them telling the father. Nope. In fact, there's kind of sort of this cover-up where the dad is saying, when can I come get my child? And on that Saturday, grandma is saying, oh, we might have a birthday party the next day. Oh, I don't know if she can come home. Well, she's in the hospital. Grandma, right, who this defendant had told you can be the supervisor for this child, right, when she has contact with this child. On June 12, 2026, she told CPS that she had expressed to both the baby's father, right, and this defendant, she'd already expressed to them that she no longer wants to supervise the visits because she is too old and has a life of her own. When they discussed with her the marijuana, she advised she uses edibles and her estranged husband smokes. CPS asked her if marijuana is kept in the house. She said it's in her bedroom. They asked if any could have dropped that the child could have gotten into or been in her bedroom. She said it's possible because there are always a lot of kids running around the household and she can't keep up. She stated everyone uses marijuana and she treated the situation as less significant than it was. So I'm not sure what kind of weed funhouse we've got going on here, but it's completely unacceptable. They interviewed her on June 8th, right when the child had gotten out of the hospital. And just so we're clear, Judge, Grandma actually told this defendant, you gotta take her to the hospital. Why? This 14-month-old is lethargic. Her eyes keep rolling back in her head. She's not able to walk and she refused a bottle. Where's the defendant? Where is she to notice this? Why isn't she taking this child to the hospital? Why doesn't anybody care?
This is bond conditions. On the other file, she's not to be in the presence of any third parties who have marijuana. CPS is involved now?
CPS is involved, and I want to talk a little bit about that now.
Okay.
So they did actually meet with mom, defendant, and grandma last night. Mom is refusing, defendant is refusing to adhere to a safety plan. They said, please take this child, put this child with a relative. And what does this defendant do? She says, I'm not giving the child back to the dad. Nope. Here are 2 names of relatives that the kid can stay with. Doesn't provide a last name. Provides an address. It's the same address as grandma. Grandma who has told CPS, this is too much for me. Grandma who has said there's marijuana everywhere in this house.
Now let me interject that my order of April 15th says very specifically, ma'am, because you just put up your hands like this, like something's wrong here, and I'll wait to hear from you, but it says, follow all family court orders, recommendations, and all recommendations of CPS. That would be a recommendation from CPS is what you're telling me, is that correct?
Absolutely.
Thank you.
Absolutely. She's not complying with the safety plan because guess what? They said put the child with a relative. And you know what? Where was the child last night? Still with mom, still with grandma. It's not with somebody else. And also, interestingly enough, they asked her, hey, will you take a drug screen last night? She says, no, I'm not taking one. She says, I'm taking one tomorrow, which I guess, I don't know.
Did she take one?
She did not.
Okay, guess what we're gonna do right now? We're gonna take a break. Ma'am, you're going downstairs for a drug screen right now.
I'd ask that an officer.
I'm gonna just ask the deputy. Can we have a deputy escort her down to probation for a drug test? Thank you.
Probation.
Thank you. And you administered a drug test. Was it positive for anything?
It was negative for amphetamines, cocaine, fentanyl, methamphetamines, opiates, oxycontin, and tramadol.
However, you don't test for marijuana anymore?
We don't have those on our instant test, no.
The sample that she gave, can that be sent?
This cannot. We could urine test her and send that one out, or we could send her to AdverHealth and have her test today.
Oh, she's not going anywhere, I think, but we'll see. But she could give another sample and we can test
We can
that.
do a urine sample and send
All
it
right.
out to her.
Appreciate doing that. Thank you very much.
Yes.
And Judge, I think there was I don't know if the court received an email from probation downstairs regarding a statement this defendant made downstairs about, we'll see what happens. We'll see what's on the test. So it's not like she's even denying that something would come up further. She refused to be tested yesterday by CPS. You know, of course, I'm conjecturing at this point, but if she really had nothing in her system, what would she have to hide? For all those reasons, I'd ask that you revoke bond. If you are inclined to not revoke bond, I have a whole list of conditions I would ask that Your Honor put on, like that she immediately hand that child over to CPS immediately.
Where is the child right now?
I presume with grandmother at the house.
So father was denied picking the child up?
Correct.
Okay.
Correct.
Okay, well, let's not get to those requests right now. We hear from the counsel and defendant. Sir, if you could come up to the podium with your client. Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and the penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any illegal drugs, marijuana, alcohol yesterday or today?
You want me to be honest? Yeah, I thought
Yeah, I want you to be honest. Otherwise, it's
I'm sorry.
perjury.
I thought, I don't know what I was coming here today, but I was scared and I smoked yesterday. Someone handed me a joint and I hit it.
And you understand that's per probation and bond conditions, no marijuana, not to be in the presence of it, not to use it.
I am aware, Your Honor. Yes.
Okay. And are you still feeling the effects of the marijuana?
No.
Are you supposed to be on medication that you're not on?
Marijuana. I have a med card and I'm on bond, so I'm not allowed to smoke.
Well, you
So I
are,
haven't been, but
you
I
are
messed
with,
up yesterday.
ma'am, you are with the medical card if you gave that to probation. Did you give that to probation?
Yes, I did.
Well, did you use it as prescribed or not?
Yeah, yeah. I mean, I haven't been using it as prescribed because my lawyer told me my bond I couldn't.
Well, you can, except that for medical reasons, you can. I'm not a doctor. I don't override doctors. But that was not even raised to my knowledge. But okay.
And I've been emailing Miss Wanji trying to get her to talk to you about that. She won't return my phone calls, my email. But I haven't heard from her.
You have pretrial services and you also have a probation agent.
Yeah, and then she told me my lawyer needed to amend my bond conditions. I'm not allowed to smoke while I'm bond probation. They don't, So she talked to my lawyer and said they need to.
Okay.
I have not been the attorney of record for this, Ms. Barnhill, since the inception of this case or for any other case. I appear before the court on her behalf today, equipped with a pleading I received from the prosecuting attorney's office titled People's Emergency Motion regarding bond. It's new information, to be sure, but I don't see any allegations. No one is, it's being deduced without evidence that somehow Ms. Barnhill is responsible for giving the child marijuana or allowing the child. And I don't think that there's any evidence to support that whatsoever. What the problem here is marijuana. It's not depriving these three children of their mother. The children didn't do anything. She's got three. One, the oldest is 8 years old. School just let out for the summer. She has a 2-year-old, and of course, this youngest one, 1-year-old. Ms. Barnhill has indicated to me that she does have an apartment and she does have an adult staying with her, share the rent, and so forth, who could act as a supervisor of those visits if the court saw fit. If you take the marijuana out of the equation, we don't have a bond violation. We wouldn't have a hospitalization.
Trayshawn, I heard he made the call, whatever is concerned. He's also the person that didn't get the memo about CPS telling me I have to have someone else. Like, okay, I gave them names, numbers, last names of my cousin, other people that could take my child for me in the meantime. He called my mom. My mom is his babysitter. That's why my children were with them when I was in jail, because I couldn't watch them. So they have my mom take care of the kids if I can't.
This is the mom who leaves marijuana around.
Yeah. And then you told me that she had to be the supervisor.
Well, nobody
wasn't-
explained to me about her marijuana use, that it was in the house or any of that. And that was supposed to be verified by, I believe, either pretrial services or probation. So we'll deal with that. What else?
And I'm not keeping he gave us the kid. That's why we have the kid right now, because he gave us, her. So I'm confused as to, she's saying all this stuff. I wouldn't follow the safety plan. Yesterday, I helped the lady make the safety plan. So I'm confused.
So do we need to have a hearing or get her on the phone? We can ask, because if you lie to this court, it's 93 days contempt, 93 days under $7,500. I suppose you don't have the $7,500. I don't have it either, but you got 93 days. Additionally, if the father came over and asked for the child and there was an issue, why didn't you give the child back to the dad?
We did. I'm confused. He never
Well, I'm
asked for
confused.
this child.
Okay, we can have a hearing, I got all afternoon, and well, let me just
I'm just
ask
trying
you,
about
if you
when
interrupt
she
me,
was
it's
in the.
93 days.
Alex, you don't, okay? You only speak when she asks you a question. That's
Thank
it.
you, counsel. So I am unclear why it took the father to get this child or your mother to get this child to the hospital and why you didn't call or take that child to the hospital.
I did. I'm the one that took her to the hospital. I saw something was wrong and I'm like, I should take her in, shouldn't I? And she's like, yeah, it looks like she's having a seizure. Like, we didn't know what had happened. So I'm like, okay, I'll go take her, you know. And I took her to the hospital.
Child is what, 1.5 or 14 months? How old?
Yeah, 14, 15 months, yes.
Where were you? I've got 5 kids.
I
They're
was-
14 months. I'm following them around. I know whether they're getting into something or not. Why is that child allowed to go in your mother's bedroom where you know there's marijuana and then ingest probably gummies that she thought was candy? Where were you?
I was doing the laundry. I was in the laundry room.
You don't know the exact moment the child may have ingested something.
Yeah, but that's the only time I took my eyes off of her, was when I was in the laundry room. I was with her otherwise, so.
Anything else you want me to know?
There's a bunch of stuff I want you to know, but nobody really cares what I have to say.
Ma'am, I'm here, I'm listening, I've asked you. If you don't want to speak, then don't. But if you do have something to say, I always take the time to listen. So what is it you want me to know?
I don't have nothing to say.
Okay, on behalf of the people.
Your Honor, CPS is not doing, it's the real problem, well, I think this defendant is the real problem. Not marijuana, no. We have all these adults in the house and nobody's watching a 14-month-old. That's absurd. What, does she do laundry for half the day? Give me a break. Your Honor, CPS tried to safety plan with her and said, put the child in a relative's home. She gave them, here, I got the notes right here. She emailed me the names of Marcy Guzman and Vanessa Guzman. The phone number provided was X. She was asked to provide any other last names and addresses where the child would be present. Several hours later,
Thank you.
she stated Conrad, stated there was no other last names. The phone number was not a working phone number and the address is the address of her mother. It was clear Ashley was not willing to cooperate or comply with a safety plan. She worked with CPS yesterday on a safety plan, another one, because she wouldn't do the other safety plan and CPS won't do anything. That's the problem. So sure, she's working with CPS, right, because she says, oh, I'm not gonna give my kid to this fake relative or this address of my mom's house. And CPS says, okay, well, I guess we don't have any, we don't have any backbone, so we'll just do whatever you want. So we want to get our paperwork in order, whatever. So they don't do anything. So now she says, well, I'm complying with the safety plan. That is it. And that is so inaccurate. It's ridiculous. I don't have anything else to say.
Thank you. Counsel, anything further?
Your Honor, I have no information with respect to a safety plan or CPS involvement. I don't know. I'm unable to assist the court in that regard. But it is, I think, significant that it was Ms. Barnhill herself who took that child to the hospital. And the biological father, there was a no contact order, so it would be improper for her to notify him by telephone or to have someone else in her place notify him.
No physical or emotional abuse, no compliance with CPS orders or recommendations, no ability to disobey or not comply with CPS or family court orders. And there was no appropriate supervision of the child. All of these things were ordered. And what I get is a no, 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 which means 0 + 0 + 0 + 0 + 0 equals nothing. What I do have in this equation is a lot of excuses, a lack of accountability and responsibility. You're crying now, but as you sat over there, you did this. And were shaking your head and making fun of what was being said. And downstairs it was reported, and I heard your attorney say, don't say anything. Well, it comes back to me, your attitude and what was said down there, you don't really care, man. The root of the problem is you. When you have a child, laundry, cooking, whatever, you make sure that child is safe. You put him in a pen, in a walker, you bring the laundry out to the child, you bring the laundry.
The hearing before the court was in a matter of the people of the state of Michigan versus Ashley Page Barnhill, and it concerned an emergency motion filed by the prosecution regarding the defendant's bond. The proceedings were driven by a deeply troubling set of circumstances involving the safety of young children, particularly a 14-month-old baby who had recently been hospitalized for a marijuana overdose. The prosecutor opened by explaining what had prompted the emergency motion. The father of the child, who was also the victim in the pending case, had left a very disturbing voicemail essentially begging someone to intervene because Child Protective Services had not taken any meaningful action. The prosecutor stated that this was not entirely surprising given the history of the case, and made clear that the fundamental request before the court was to revoke the defendant's bond. The prosecutor stated there were multiple reasons why this was necessary, not only to keep the broader community safe, but specifically to protect the children involved, asserting that this defendant was a danger not only to her own children, but to any child. The prosecutor then provided background on the defendant's history with the court, noting that she personally remembered a prior case involving Barnhill from when she had served as a docket prosecutor a few years earlier. In that earlier case, the defendant had been charged with carrying a concealed weapon, but there had also been another component. The child's father, who was a victim in the current case, had called police at the time to report that the defendant had tried to hit him with her car. That matter could not be pursued because the father had not wanted to get her in trouble and had wanted to work things out with her. At the time of that incident, Barnhill had been 12 weeks pregnant. The argument that led to that confrontation had started over marijuana. The prosecutor further noted that in the pre-sentence investigation for that prior case, Barnhill had told both the court and the PSI writer that she had stopped using marijuana as soon as she found out she was pregnant, a statement the prosecutor described as incorrect, since by her own admissions she had been trying to obtain marijuana at 12 weeks pregnant. The prosecutor then moved on to the current case, which involved a charge of child abuse in the third degree. She explained how the incident had begun. Barnhill had gotten into an argument with the father of the child over money he had spent making a cake for someone who had passed away. Angry about the money spent, Barnhill threw the cake to the ground. When the father grabbed her phone in response, she used their 12-month-old baby as a bargaining chip, grabbing the infant so tightly around the arms that it left red marks on the baby's skin. The judge interjected at this point to ask whether the defendant had been with the victim at the time, given that there was a no-contact order in place. And the prosecutor clarified that the no-contact order from the earlier CCW case had not applied at the time of the cake incident, which was the basis for the current bond. When the father took the child and attempted to leave, Barnhill grabbed 2 knives, followed him, got his face, and began stabbing a wall while the child was still present in the room. The prosecutor characterized this as incredibly dangerous escalating behavior, describing a clear pattern of the defendant placing her own needs and wants above the safety of her children and of a baby. The prosecutor then described the most alarming recent development. Between June 6th and June 7th, the child, who was now 14 months old, had been admitted to the hospital for a marijuana overdose. The prosecutor told the court that this 14-month-old had been asleep for 15 hours straight, which she noted was extremely dangerous for a child that age since they need to eat every 3-4 hours. The way this came to light was not through the defendant informing CPS, nor through her telling the father. Instead, there had been something of a cover-up. When the father was asking when he could come and pick up his child, the grandmother was telling him there might be a birthday party the next day and suggesting the child might not be able to come home while she was still in the hospital. This was the same grandmother whom the defendant had designated as a supervisor for her contact visits with the child. The prosecutor then described what CPS had found when they met with the grandmother on June 12th. The grandmother had told CPS that she had already informed both the baby's father and the defendant that she no longer wanted to supervise the visits because she felt she was too old and had her own life to manage. When CPS discussed the marijuana situation with her, the grandmother disclosed that she herself used marijuana edibles and that her estranged husband smoked. When asked whether marijuana was kept in the house, she confirmed it was kept in her bedroom, When asked whether any could have dropped or whether the child could have accessed her bedroom, she said it was possible because there were always many children running around the household, and she could not keep up. She stated that everyone in the household used marijuana, and that she had treated the situation as less serious than it was. The prosecutor noted that it was in fact the grandmother who had told the defendant that she needed to take the child to hospital because the 14-month-old had become lethargic. Her eyes were rolling back in her head, and she was unable to walk or take a bottle. The prosecutor questioned where the defendant had been during all of this and why she had not noticed the child's condition and taken her to the hospital herself. The prosecutor pointed out that the bond conditions in the other file specifically prohibited the defendant from being in the presence of any third parties who used marijuana. CPS was now involved, and the prosecutor described what happened when they met with the defendant and the grandmother. The defendant was refusing to comply with the safety plan that CPS had developed, which involved placing the child with a relative. When asked to provide names and contact information for relatives who could take the child, the defendant provided 2 names but no last names, and the address she gave turned out to be the same address as the grandmother's home. The grandmother had already told CPS she was unwilling and unable to continue supervising, and had acknowledged that marijuana was readily accessible throughout the home. The judge noted at this point that her order from April 15th had explicitly required the defendant to follow all family court orders and all recommendations of CPS, and confirmed with the prosecutor that refusing to comply with the safety plan would constitute a violation of that order. The prosecutor also disclosed that CPS had asked the defendant to submit to a drug screen the previous evening, and she had refused, saying she would take one the following day. When the judge heard this, she immediately called a recess and had a deputy escort the defendant downstairs to probation for a drug screen right then and there in the middle of the hearing. When the probation officer returned to the courtroom with the results, she reported that the test had come back negative for amphetamines, cocaine, fentanyl, methamphetamines, opiates, oxycodone, and a number of other substances. However, the probation officer then disclosed that their instant test no longer screened for marijuana. The judge asked whether the urine sample could be sent out for further testing, and probation officer confirmed that a different sample could be collected and submitted. The prosecutor noted that a report had come back from the probation office downstairs about a statement the defendant had made while she was down there being tested, implying the defendant had not exactly denied that something might show up. The defendant was then placed under oath, and the judge questioned her directly. She asked the defendant whether she had used any illegal drugs, marijuana, or alcohol the previous day or earlier that day. The defendant's response was notable. She asked the judge whether she wanted her to be honest, to which the judge confirmed she did. The defendant then admitted that she had smoked marijuana the previous day, explaining that someone had handed her a joint and she had taken a hit. She acknowledged that she was aware her bond conditions prohibited marijuana use. When asked whether she was still feeling the effects, she said she was not. The defendant also mentioned that she held a medical marijuana card and had raised this issue previously, stating she had been trying to contact her probation agent about having her bond conditions amended but had not received a response. She said her probation agent had told her that her attorney would need to amend the bond conditions through the court. Defense counsel, who noted he had only recently been assigned to represent Barnhill and was not the attorney of record for the full history of the case, addressed the court. He argued that no one had presented evidence directly connecting the defendant to the child's marijuana ingestion, and that the issue fundamentally came down to marijuana exposure rather than deliberate harm. He acknowledged the defendant had 3 children, including an 8-year-old, a 2-year-old, and a 14-month-old at the center of the current emergency, and noted that she had an apartment with another adult present who could act as a supervisor. He argued that if marijuana were removed from the equation, there would be no bond violation and no hospitalization. The defendant then spoke and attempted to address some of the statements made by the prosecutor. She said the father had in fact given the children to her mother to care for while she was in jail, and that her mother had been his choice of babysitter as well. She also pushed back on the claim that she had refused to comply with the safety plan, saying she had helped CPS create the safety plan herself and had provided names and contact information for relatives. She insisted she had ultimately given the child back to the father and was confused about the accusations being leveled against her. She also addressed the question of why it had taken so long to get the child to the hospital, saying she had been the one to take the child in after noticing something was wrong, and that the child had appeared to be having a seizure. The judge pressed her on this point. She asked who the defendant had been when a 14-month-old was allowed to enter the grandmother's